to our special panel discussion now. There were heated exchanges in Nigerian Pastor Timothy Omotoso's rape trial today and yesterday. His lawyer, Advocate Peter Daubermann, locked horns with Judge Mandela Makaula and witness Cheryl Zondi. The matter is being heard in the Eastern Cape High Court in Port Elizabeth. Now, Daubermann made several claims implying that Zondi was a willing participant in her rape and molestation. Is it acceptable for Daubermann to ask the witness questions about a sexual act the way he did? Well, joining me to make sense of this is Lisa Vetton from the Tshwarang Legal Advocacy Center, as well as criminal law expert William Booth, who's joining us from our Cape Town studios, but also joining us here in the studio is Senior Associate at Ulrich Rue and Associates Vanessa Da Silva Faria. Good evening to all three of you. Thanks very much for your time. If I may start with you, Lisa. I'm just listening yesterday to that, particular line of questioning where even inches, came into, became part of the questioning. Just your overall impression, what you made of how Daubermann just conducted himself.
I think a rape trial is very, very difficult because it does go into sexual experience in often ways that can be quite graphic, especially if you're trying to define what is the proper charge that the person should be convicted of. And precisely because it's sexual, I think you have to be very careful that your questioning doesn't start to push your complainant into participating in what is really a pornographic spectacle. And I do think that some of the questions that Daubermann was asking were starting to cross that line. They were gratuitous, they were degrading. Just because one has an accused is certainly entitled to a right to a fair trial, but by the same token, a complainant is also entitled to a right to dignity. And I think there were times where his questions certainly did not give her that right. They were not necessary in any way to be proving his case. His questions about depth of penetration, maybe that may have been material if you're trying to distinguish between did a sexual assault happen or did a rape happen. But that doesn't appear to have been the case in this situation. So it seems to me to have been more of a situation of trying to leave her feeling wrong-footed, off the foot, flustered, not sure of herself anymore, to lose her confidence, and then to begin that process that defense attorneys like of breaking down complainants so they become less credible as witnesses.
Vanessa, is there a line, or is it something we make up because we, as human beings, take positions on these matters?
Well, there's not necessarily a line in terms of the court rules or anything like that. Quite frankly, it's up to the judge who's presiding over the matter at that point in time. The judge who's dealing with the matter must regulate the matter, and that's exactly what they must do. And they must decide whether or not the defense attorney or even the prosecutor is going over the line or not. And at the end of the day, it depends on the judge. But one must also remember that the role of the defense attorney is obviously to put his client's or the accused's version before the witness. And he must be in a position where he can discredit that witness in an attempt to prove his client's own version. And the judge must be careful to draw the line between whether the questions he's asking is relevant and material for his defense and for the merits of the matter, or whether he's just simply trying to startle the witness and wanting to get her, emotional, wanting to hurt her. But the decision at the end of the day lies with the judge dealing with the matter.
Vellum, can I come to you? Is there a line that can or can't be crossed from where you sit?
Well, I think one must always remember a criminal trial is and can be a very antagonistic situation. And obviously, very traumatic for a witness. I think the judge's role is to ensure a fair trial. That's a fair trial for the victim, or the witness, and the accused. So I think effective cross-examination needs to try and seek out the truth. Many witnesses come to court and actually lie. So you're there to defend your client, and you must make sure that you do that appropriately and put across his defense. But at the same time, you have to show some sort of respect for a witness. Shouting at a witness and just being aggressive throughout cross-examination is sometimes not in your client's best interest and actually can be counterproductive. But one must remember that a lawyer has a job to do, and the judge is there to ensure that a particular lawyer does that job properly. And the prosecution is entitled to object. So if you ask irrelevant questions that have got nothing to do with the matter, or you are asking questions that really are just out there to intimidate a witness, the prosecution has the role to play to object, and the judge must make a ruling on that objection.
Well, antagonistic, as you say, a criminal trial is. Lisa here raises an important point, and especially given where we are as a country, but also, I mean, throughout the world when it comes to, you know, the rights of people who are wronged. Where, in your view, does the witness's right to dignity come in? And especially if you look at the past couple of days with Daubermann, you know, putting questions to the witness.
Well, I think at the end of the day, the judge has got to ensure that the proceedings continue in a proper and fair manner. And that's fair to the witness as to the accused. So if a lawyer is merely hell-bent on intimidating a witness or tearing the witness down for no apparent reason, then the judge must intervene and the prosecutor must object. Because every witness is entitled to his or her dignity, and that must be respected even in a criminal trial.
Which the judge did a couple of times over the past couple of days. But should it be his, the judge's that is, and his alone, to actually take into account or keep in mind all the time?
Well, I think every lawyer must realize that he has an ethical duty to the court, and that, therefore, the questioning must be within certain parameters. But, you know, because it can be a very confrontational situation, sometimes, you know, things can get out of hand, and that's what I mean where the judge has got to come in and curb the proceedings. But I think as a criminal defense lawyer, you need to know that you can't just ask questions for the sake of asking. And never ask a question if you don't know what the answer is going to be, because that is going to be seriously contrary to your client's case. So any effective cross-examiner, you know, sometimes the quieter the questions are, the less antagonistic they are, the more effective they can be to achieve what you're looking at, is to try and get to the truth and defend your client, but not at all costs.
Okay, I've got to let you go. Apparently, you need to be somewhere else. But one quick last question: in your experience, do lawyers, defense lawyers here, I'm talking about, take that into account, or even the ethos? For example, what we're trying to do here as a country, we may not be as successful as we would want to be, but we are trying. But do lawyers take that into account, or are they preoccupied with making sure that they represent the interests of their client as best as possible, and in doing so, they have to push the envelope as far as they possibly can?
Well, look, as I said earlier, you've got to defend your client. I mean, he is your client, and you've got to present his case to the court. And you've got to cross-examine according to your client's instructions. But there have to be boundaries to that cross-examination. And, you know, when you get into a mudslinging match with a witness, that's not going to be in the best interest of your client. So you've always got to retain some decorum as a lawyer, because people are watching you and they are going to be saying, well, hang on, this lawyer is just interested in destroying the witness, but not actually seeking the truth, and in fact not really representing his client to the best of his ability. So you must retain some dignity. You are a lawyer, you've got ethical duties towards the court and to the public. But at the other side, you also need to know, and one mustn't forget, people come to court and sometimes they don't always tell the truth. That is why you need to know that you've got to dig to try and get to the truth, but as I say, not just to destroy the witness for the sake of doing that. That is not going to help your case at all, or your client's case at all.
Okay. Well, let's release you. Thanks very much for your time. If I may just come back to the two of you then here in the studio. Now, Vanessa, I mean, Willem made the point that it may not be in the interest or in the best interest of the client if the defense lawyer, for example, budges, you know, and is seen to be rude and all of that stuff. But is that really the issue?
Well, you know, at the end of the day, the defense lawyer needs to get his case across. But the most important thing is he needs to find out what the truth is, and he needs to assist the court in finding out what the truth is. And that is essentially what is in the interests of justice. So it's not necessarily just about budging the witness or getting them to say whatever he wants him to say. It's about finding out what the truth is, finding out whether it is the witness who is lying, or finding out whether it's the accused whose version is incorrect or who doesn't make sense. And when a defense attorney goes into the minor details of things, it's because there's a certain test that must be applied in a criminal matter. And, you know, in any criminal matter, the state must prove something beyond a reasonable doubt. And as a defense attorney, you need to go through every little thing and attack every possible thing that you can, not only to get your client's version out, but to find out what is the actual truth, and to determine whether or not the state can prove the allegations beyond a reasonable doubt. If there is some kind of doubt of it being incorrect or being untruthful, then that is certainly what must be brought to the court's attention.
But surely, you don't need inches to give you that.
Well, I do admit that question was quite strange, specifically just taking into account the actual general principles relating to a charge of rape and what constitutes rape. But, you know, at the end of the day, if his instructions are to fight the nitty-gritty and to get as much detail and find out exactly what might be a lie and what might not, then those are the instructions he needs to follow as the defense attorney.
And then it brings us to this question, Lisa, I mean, something whether or not, you know, one stands by or sympathizes with Cheryl, but the reality that it has taken us so long and so much to get to where we are right now, in terms of getting people to come forward, you know, and bring perpetrators to book, and to get the courts, in fact, even before you get to the courts, to get the police, you know, to do the sort of things that they need to do to be able to assist, you know, witnesses, and then for the courts to be able to prosecute them. Should we even, I mean, perhaps how best, maybe that's how I should ask it, how best do we then make sure that we assist our judicial system, while at the same time not necessarily trampling over the rights even of the accused?
There are a couple of things that one can do. The first, of course, is to prepare your complainant really, really well, is to give her a sense of what are the questions you're going to be asked. If you start to feel this way, if you start to feel like you're losing your confidence or you're being flustered, this is how you manage it. Go in there knowing you're going to be called a liar. Go in there knowing that this is not personal, this is just a defense attorney doing their job. You're also not going to be allowed to tell your story in the way you want. You need to tell it in a particular way. So explain to somebody and you let them know what it is that how they're going to have to testify, so that they feel a little bit more in control by knowing what's going on in the process. You also tell them about things like the option of having an in-camera hearing, which means that it can be kept private. You don't have other people wandering in and out. You can even testify in a different room via closed-circuit television. What we would like to see, I think, is a much more proactive role of a prosecutor, for example, I think sometimes in being a little more assertive in protecting from the kind of cross-examination that we've seen here. And I think we might see that if we had a greater profusion of sexual offences courts available in South Africa, where we had specially trained, expert, specialised prosecutors who know what the law is, when you intervene, who might understand how you prepare somebody properly, how you call an expert witness to explain why somebody might not have reported the matter immediately at the time. So there'd be quite a lot we could do. And I think allied to that, obviously, we'd want to do some more training for the magistracy as well as the judiciary around understanding rape better, especially issues like why somebody might delay reporting. And I think another area we'd obviously also want to focus very definitely on is dealing with children and dealing with people with disabilities, intellectual impairments, because they also don't fare well in the system at all, and our system has not adjusted to enable them to testify. And they're often real targets and really vulnerable because of their disability.
Vanessa, I wanted to weigh in on that, because the reality is that we're talking about this particular case today because it's been on television, and that's what looking at how the defense lawyer conducted himself, a lot of people got were outraged. There are many such cases happening throughout our courts, and the situation gets even worse as further away you move from the urban areas, for example, where access to really good lawyers and support systems simply isn't there. Again, I'm asking you that same question I asked Lisa. What can we do to make sure that those things, are there, or there's more of it?
Yeah. Well, I agree with Lisa completely. We need to look into the people who are actually tasked to deal with these matters. So we need to look into the training of not only attorneys, but also, legal aid, for example, who are the people that are out there to assist those who are less fortunate and who can't get the assistance of the top shot attorneys or whatever it may be. We must also look into the training of the judiciary and the magistrates and seeing how they must deal with issues. But I think it also we need to focus on the victims and how to prepare them. And one of the biggest things is the victims need to realize that in reporting a case and in seeing a case through as they should, they're going to have to unfortunately relive what happened. That is the only way they can tell their story. And they need to be able to be prepared and feel comfortable enough to tell their story and know that they're going to receive backlash and that there is going to be a defense attorney on the other side fighting with them, trying to discourage them. But they need to be trained and shown how to stand their ground and tell their story as it is. At the end of the day, if they're not lying, if it is something that really did happen to them, then justice must prevail. And it is in the interest of justice for everyone to make sure that the truth comes out and that these victims are essentially protected and that justice prevails.
As a last point, to both of you, the role of television. We're sitting here discussing this because a lot of people saw it and expressed their outrage. And none of that would have happened if people weren't watching. But on the other hand, as other people have raised this issue, there's the issue of a Daubermann playing to the gallery. Trying to win points and trying to win, public sympathy as this good lawyer who can actually break a witness down. The role of television.
It's very complicated. On the one hand, it can be very educational, but I think we've got to bear in mind that the kind of trials that make it to television tend to be exceptional. They're not run-of-the-mill. So they don't give people necessarily a full idea of what goes on in court. And I've observed a lot of trials. I've prepared a lot of complainants for trial. They're not all as horrible as what we saw. And in some situations, they can be very empowering. So I think it is important that we also say to people, this is not necessarily the only way it happens, so don't be frightened and put off from reporting. And I think, yes, there is very much a possibility that Mr. Daubermann was playing to the gallery, but it has backfired on him very badly.
Quick last word from you, Vanessa.
I agree with Lisa. It has its pros and its cons. It's very educational, but I think the community must also just be educated as to the actual roles that people play in court and what the procedures are and how it should be followed, not versus how people act as if it should be followed.
Thank you very much.
Thank you
for coming through and for your insights. Lisa Vetson from the Tshwaranang Legal Advocacy Center and Vanessa da Silva Faria. Thanks.